Okay, so thank you everyone for joining us today. My name is Jie Huang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the visa options available for individuals with extraordinary abilities in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We are continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. First, we will send out a copy of this PowerPoint that will be used in this webinar. We will also send you all a visa guide, a comprehensive guide to all of the visa categories that we will be speaking about today that you can use as a reference. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button on our channel, as we do regularly upload a variety of immigration law related videos that can be helpful and informative to you. We will also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. Today, we're very lucky to have Kelly Legrand Wiener, who is a partner of the firm with a wealth of experience handling cases in the visa categories we'll be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them in the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started.
Thank you, GA. So we're going to talk briefly in the first part of the presentation about, O1A, O1B, and EB1. And later on in the presentation, GA will walk us through the National Interest Waiver, which is another category that is kind of peripheral to the extraordinary ability categories. So what are the extraordinary ability visa categories? The most commonly, known ones are the O1A and the O1B. These are temporary visas that people can use to come to the United States to work in their area of extraordinary ability. For O1A, this is for people who have extraordinary ability in the sciences, education, business, or athletics, and it has quite a high standard. You have to prove you are one of a small percentage who's risen to the very top of your field of endeavor. There's also the O1B, and this is for people with extraordinary ability in the arts and also extraordinary ability in motion picture or the television industry. And there's slightly different standards here. So for the arts, the person must have achieved distinction in their field, which is a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So this is slightly, easier to meet than the O1A. And we'll talk a little bit more about that later in the presentation. The standard for the motion picture and television industry is also separate. This is a bit higher than the standard for the arts. You have to show that you have achieved a level of acclaim substantially above that of your peers. All right, the EB1A green card. So these categories, the EB1A and the National Interest Waiver, these are permanent. So the O1A and the O1B that we just talked about are temporary. You can kind of get these and renew them to the extent that you continue to have extraordinary ability work in the United States. However, if you want to live and work in the United States permanently and have kind of more flexibility in the work that you're doing, a green card may be the best option. So for the EB1A green card, this is for individuals with extraordinary ability in the sciences, arts, education, business, or athletics. So there's not kind of separate categories for the arts the way there is with the O1A and the O1B. This is all combined into the EB1A. And the standard is the higher standard. So it's the individual who has risen to the very top of the field of endeavor and can show sustained national or international acclaim. So this is a very high standard to meet. This means sometimes if somebody has gotten an O1B under the standard of distinction, but is maybe perhaps kind of early in their career, maybe you got a really difficult request for evidence on your O1B petition, going straight to an EB1A might be difficult. That might be something where just because even if you are granted an O1A, you may not necessarily qualify immediately for an EB1A. And we'll talk a little bit more about how they adjudicate these later in the presentation. But just to keep in mind that qualifying for an O1A or O1B does not automatically mean you do qualify for an EB1A, even though the standards that they describe are quite similar. I'm going to talk briefly about the EB2 National Interest Waiver. So under this category, the EB2, there is a threshold requirement that you have either an advanced degree, which means a U.S. master's degree or higher, or the equivalent. Equivalent of a U.S. master's degree would be a bachelor's degree plus 5 years of progressive post-baccalaureate work experience once you meet or exceptional ability. So if you don't have the educational threshold requirement, you can try to qualify through exceptional ability, which is a slightly lower standard than extraordinary ability. You still need to prove that you meet at least 3 out of 7 criteria. I'm not going to list them here, but they all have to do with demonstrating that you have that exceptional ability in your field. Um, Once you've proven you meet this threshold requirement, then you have to show that you meet this extra test. So, under the EB2 category, normally a US employer sponsors an employee through the green card process where they have to test the US labor market and see if there's any willing, qualified, and available US workers for a job. For the National Interest Waiver green card, you are asking the government to waive that test. And you're saying they should waive it because you are engaging in an endeavor of substantial merit and national importance. You yourself are well positioned to advance that endeavor based on your history or your track record of accomplishments. And therefore, on balance, you should waive this normal requirement that they have to test the US labor market. So this can be a good category for maybe people who are not quite at the EB1A extraordinary ability level yet, but perhaps have some, very impressive, accomplishments and are working on an endeavor that has substantial merit and national importance to the United States. All right, let's talk a little bit more about the O1A visa and what you need to demonstrate to be approved for this type of visa. So either you need to show that you have received one major internationally recognized award, like a Nobel Prize or a Pulitzer Prize, or much more commonly, people will qualify on the basis of showing they have met at least 3 of the following criteria. And of course, if you meet more than 3, that is much stronger for your application. So these are things like receipt of nationally or internationally recognized prizes or awards, memberships in associations in your field, which require outstanding achievements of their members, published material in major trade publications or major media about you or your work in the field, original contributions of major significance in your field, authorship of scholarly articles, a high salary, participation on a panel as a judge of the work of others, and employment in a critical or essential capacity for organizations with a distinguished reputation. So while it is good to meet more than 3 of the criteria if you can, you also want to think strategically about what information you're going to include. So let's say you're a member, for example, any lawyer can join any bar association just by virtue of being licensed as a lawyer. This is really not going to work well under the criteria of membership of associations because it doesn't require any outstanding achievements. Anybody who has the basic license to participate in the legal field can join this bar association. So you do want to think about, not including evidence that will make your profile look weaker. You want to include evidence that will really make the profile look very strong. So if you've won student awards, through your university, those are generally not very helpful. However, if you won an award where you were competing against other, people who are actually practicing in the field and you were happened to be a student at the time, that could still be worthwhile. So it is good to discuss all possible evidence you could include with your attorney, but then you want to be really strategic about what evidence you ultimately decide to include to make sure that your profile presents as somebody who has risen to the very top of their field. All right, for the O1B, so you need evidence of at least 3 of the following, and this is kind of continued on the next slide. Um, You also could qualify by showing that you have been nominated for or received a significant national or international award in a field that's relevant to the arts, so an Emmy, a Grammy, things like that. You'll see here the criteria. You have to show you meet at least three, and they are focused on the arts. So, having performed and will perform a lead or starring role in a production or event with a distinguished reputation, critical reviews or other published material in major trade publications about you, evidence of performing and a lead starring or critical role for organizations or establishments with distinguished reputations. And these are distinguished, right? So productions and events and organizations and establishments are distinguished in the regulations. So you do want to think, about what would be relevant for your field. We can go to the next slide. So evidence of, major commercial or critically acclaimed success in the performing arts is shown by box office receipts or record, cassette, compact disc, or video sales. Significant recognition for achievements from organizations, government agencies, or other recognized experts, having commanded a high salary, or other comparable evidence. As noted here, this category is not available for those in the motion picture industry, but if you're applying in the arts, you do have to show that the other criteria are not relevant to you. So it can be kind of difficult to incorporate this if your field is one that traditionally would have the other types of evidence that are listed here. That being said, the arts is a very broad field, and there certainly are kind of creative uses of the O1B for the arts. For example, tattoo artists, people who are kind of drink mixologists. So that may be a circumstance where you may be able to bring in other comparable evidence based on how you're defining the industry, and how new the industry is, whether it may not have some of these more traditional pieces of evidence like box office receipts or something like that, which would obviously be more relevant for certain types of O&B applications, but not for someone who is a tattoo artist. Uh, Perfect. We can go to the next slide. So let's compare between the O1A and the O1B. So as we described previously, the O1A is for fields of science, education, business, or athletics. The O1B is the arts and motion picture or television industry. The standards, as I described, are slightly different, with the O1A having a higher standard than the O1B. In terms of how long they can be issued for, you can get an O1A for 3 years or an O1B also for 3 years, and then you can renew them in increments of 1 to 3 years. So if you are just extending the current engagement, then you can get a maximum approval of 1 year for that. If you're engaging in a new set of projects or a new employment situation, you can potentially get up to 3 years. And these are renewable indefinitely. So there's not a time limit the way there are for an H-1B visa or an L visa. So this can be very helpful, particularly if you're somebody who is touring a lot, you're coming in and out of the United States, you'll need to come back, over time. This type of temporary visa can be very helpful for that. However, you'll only be able to get it for the length of time for which you do have extraordinary ability work. So for example, somebody who is, coming to perform in a play, once that play is over, if the play is running for 6 months, you may not be able to get 3 years unless there's other work in your field or in your area of extraordinary ability that you plan to undertake while you're in the United States. Your family can also come to the US with you, your spouse and any unmarried children under 21. They cannot work, but they can attend school. Both the spouse and children can attend school if they choose while they're in the United States. Great. Let's talk a little bit about the EB1A extraordinary ability requirements. As described previously, the standard looks very similar to the O1A. So it's somebody who has risen to the very top of their field, can demonstrate sustained national or international acclaim. And the structure of qualifying is very similar as well. You either can show that you have achieved one major award, like a Pulitzer Prize or a Nobel Prize, or three of the following criteria. And these criteria are kind of mixed. They're quite similar to the O1A. And then they incorporate some of the O1B requirements as well, since the EB1A is for science, education, business, athletics, and the arts as well. To qualify, you'll need to meet at least three of these criteria. More are obviously, better. And we'll move to the next slide to talk about the adjudication standards for the EB1A. So the way that they adjudicate extraordinary ability cases is through something called the Kazarian analysis. And what this means is they will first look at the evidence to see if you meet the plain language of the criteria. So have you submitted evidence that you've won, nationally recognized prizes or awards? Have you submitted evidence of membership of associations, that require outstanding achievements of their members? And then after they look at that, in the second step, they're going to review everything in totality. And based on the quality of the evidence, they will make a final merits determination to see, are you someone who's risen, to the very top of your field? And this is why, as I described previously, it's very important that you not include any evidence that would weaken your case or make it look like you're reaching or you're trying to find things to supplement your case. So you really do want the officer to leave the adjudication after they've looked at all of the evidence, they've read all the letters. You want them to leave with the impression, wow, this is somebody who has risen to the very top of their field. This is a leader in the industry. And so you don't want to include anything that would kind of take away from that final merits determination. And that's why it's very important to be strategic in what you submit and not necessarily submit every single thing. For example, maybe if you had some letters from your O1B petition that were more like recommendation letters that said, yes, this person did a very good job. You may want to either redraft those or perhaps not include them because you don't want that impression in the officer's mind, that could take away from them feeling that you are somebody who has risen to the very top of your field. All right, so we're going to turn now to the National Interest Waiver, and GA will walk us through that.
Great, thank you, Kelly. Yeah, so let's talk a little bit about the EB2 NIW. And there can be quite significant overlap between, extraordinary ability applicants and the EB2 NIW. If, especially if you feel like your profile is not as up there as to be seen as the small percentage who have reached the very, very top of your field. But nevertheless, if you can show that your work would have a broad impact to your field, contributing to advancing the field in some way, maybe you could consider the EB2 NIW as an alternative pathway towards a green card. So let's walk through the requirements first. So in order to qualify for the EB2 NIW green card, you first need to meet the EB2 threshold requirement. And this is the same requirement even if you're, getting, a sponsorship from a U.S. company based on a job offer. Everyone who wants to qualify under the EB2 category needs to meet this requirement. So there are two ways you can meet the EB2 threshold requirement, which is by either showing that you have an advanced degree, which is defined as a master's degree or higher, or the equivalent of a master's degree, which can be shown by showing that you have a bachelor's degree in your field plus 5 or more years of post-baccalaureate progressive work experience in the profession that is related to your bachelor's degree. Now, let's unpack that a little bit. Now, one thing to note is that if you have a master's degree that you got in a foreign institution that is not a U.S. degree, it is very important to get what is called a U.S. education equivalency report that can confirm that that level of education in your home country is in fact equivalent to a US-based master's degree. It is very important because without that, you may have trouble meeting the EB2 threshold criteria. Now, when you're trying to meet this threshold through showing that you have an equivalent of an advanced degree by having a bachelor's degree plus 5 years of post-baccalaureate progressive work experience, it is not only important to prove that you have the bachelor's degree, and the same consideration applies if it is a foreign degree. You definitely want to get that U.S. education equivalency assessment that confirms that that degree is indeed a bachelor level according to U.S. standards. But you also need to prove that you have 5 or more years of full-time post-baccalaureate progressive work experience. And what that means is that the letters that confirm this experience, and you would get these letters from your previous employers, must not only confirm that you work for 5 years and not only confirm that you work for a full time, but they should also confirm what your duties were in terms of the responsibilities and your job title and things like that, and confirm how it has changed over the years. Now, when we speak of progressive work experience, we speak of job duties and responsibilities that go up over time in level, upwards in complexity, upwards in, seniority, upwards in the level of work that you are doing. So detailed employment confirmation letters from those previous employers would definitely play an important role in proving that you meet this threshold requirement through a bachelor's degree plus work experience. And another thing to note is that both the degree and the work experience must be related to your proposed endeavor. So, and USAS has been expressing that they will look at this, more and more strictly as time goes on through things like, changes in their policy manual and things like that. So, for example, if you have a bachelor's degree in software engineering and if you have work experience in a completely different area, like baking, for example, that would not combine so well. And if you have a master's degree in software engineering, but then if your proposed endeavor is to be a baker, that disjunction would not work well for qualifying for the EB2 NIW. Really, it is important to ensure that your degree and your experience is lining up with what you're presenting as your proposed endeavor. Now, let's look briefly at exceptional ability in the sciences, arts, or business, which is an alternative way to qualify for the EB2 threshold. Now, in order to show that you have exceptional ability, what the government is looking for is, do you have a degree of expertise that is, quote unquote, significantly above what is ordinarily encountered in the field? And so you do need to show some sort of distinction between what the vast majority of people are doing in your field. However, you don't need to show that you're one of the top small percentage of the field that have reached the very, very top of the field, as would be required in an EB1A context. So definitely it is a lower standard than extraordinary ability that we discussed in previous slides. And how do you show exceptional ability? You would want to show at least 3 of the evidences out of 7 criteria. This can include any degree in your field, letters documenting at least 10 years of full-time experience in your area. If you have commanded a high salary, you can also use that. Membership in professional associations. And note here that in this context, any professional association can work. It doesn't necessarily need to be a professional association that requires extraordinary ability. So if you look at the nuances of the evidentiary criteria, they are definitely quite different. Or other evidence that you have attained a significant recognition from others in your field. Professional organizations, government organizations, or peer experts that would be helpful towards meeting exceptional ability. Now, it is important to note that that is only the first step of a EB2 NIW petition. Now that you've met the first step, which is the qualifying under the EB2 threshold criteria, the other part and very important part of an EB2 NIW petition is to show that you actually qualify for a national interest waiver. And why is this important? It is important because the national interest waiver waives a certain requirement that you would otherwise be subject to, which is the labor certification requirement. Usually, for someone to get a green card under the EB2 employment based category, you do need a U.S. job offer. You do need a U.S. company to sponsor you and actually test the labor market to see if there is anyone else in the United States who has the minimum credentials to fulfill your job, basically. And only when they can prove that there is no other U.S. person with minimum credentials, then the company is allowed to sponsor the foreign national. And this is quite a complex process, right? And it can also take a lot of time to go through this labor certification process. However, if your case qualify for an EB2 NIW, the foreign national actually is allowed to self-petition for the green card without needing a U.S. sponsor, without needing a U.S. company-based job offer. So that is definitely a huge privilege and a huge exemption that you're getting, which is why the government has outlined those factors, the NIW 3-pronged Danazar factors, that the applicant needs to prove in order to, show that they indeed qualify for this special treatment under the NIW program. So let's walk through the 3-prong matter of Danazar factors. The first prong is that the individual must prove that the proposed endeavor has both substantial merit and national importance. And what does substantial merit and national importance mean, really? An easy way to think about this is that the government is looking for more than just doing a good job for your immediate employer or for your immediate clients if you're an entrepreneur, for example. So, and I keep using the example of a baker, which is one of the examples that USCIS uses in its most recent iteration of the policy manual. But if you are, running a small bakery and then you're only benefiting the immediate clients who come to the bakery, um, you are not really showing that you're making a broader impact to the field in some way. And let's contrast that with, someone who is a researcher who is helping a pharmaceutical company develop a new drug that will, enhance the treatment efficiency for, some kind of difficult disease, right? In that latter case, you can already see that there is a lot more of a broader benefit to the field that your work can have by advancing medical practices, improving, scientific knowledge, improving public health, for example. And those kinds of broader societal and scientific and welfare benefits are kind of closer to what the government is looking for when they are asking for a proposed endeavor that has both substantial merit and national importance. Now, how do you prove that your endeavor would have such merit and importance? Because it is, after all, future looking, right? So expert letters can definitely play a big role to develop that narrative. And especially if you can get letters of support from someone who's involved in government agencies that cover the field. So let's say you're someone working in environmental, sustainability. Could you get a letter from, an agency that really deals with that area? And could that agency representative describe what are the challenges that the government is seeing in this area of environmental sustainability? And more importantly, what can the applicant's specific project do to fill those gaps? What can your project do to, really improve the way that things are done for the field as a whole, as opposed to, just creating profit for a company or, just serving the needs of the immediate clients by using tried and true traditional established methods? Really, a good way to think about this is the government is looking for some innovation in the way things are done that can really, drive forward progress for the field more broadly. So definitely it is very important to get evidence which is as specific as possible to the project that you are proposing. If you are an entrepreneur, for example, you can include a very detailed business plan that outlines the challenges of the technology that the field is, currently experiencing, and developing a detailed plan of how you're going to, offer, something that can change the way things are done. The next matter of Danaher criteria is focus on the individual themselves, right? So the second criteria is that the individual must prove that the person is well positioned to advance the proposed endeavor. And you can prove this in a variety of ways. The most, relevant thing would certainly be education and experience. Does the person have relevant education, relevant experience in the professional field that will position them well to drive forward the endeavor? If you're someone who's proposing to do medical research, for example, and you have never done medical research in the past, that would definitely be a difficult case to meet for the well-positioned prong, because you cannot show that you have the necessary knowledge and skills to drive forward that endeavor that will, significantly impact the field. You need to show that you have made at least some impact in the field in the past to, convincingly show that you will continue to make such impact in the future. So a track record of success is definitely a catchphrase that the government likes to use when they evaluate the second prong. You really want to develop a good, portfolio of projects that you can show as examples of what the applicant has done in the past that is similar to what the applicant will do in the future, which could, provide a good persuasive basis on which the government can find that this endeavor will be successful. Intellectual property. One note about intellectual property is that it can be very helpful towards both, meeting the well-positioned prong, and it also can be helpful kind of signaling, a broader impact that can, also benefit the first prong as well. And by intellectual property, we mean things like publication of patents with the development of new technology, for example, or publication of academic journal articles, right? If you're a researcher and if those kinds of articles have been cited, a large number of times, those things can be helpful to show that you're really at the forefront of your field and contributing to the advancement of knowledge in an area of science or, any relevant area in your field, actually. It doesn't necessarily need to be science. Things like, if you're an entrepreneur, you can really be creative on what kind of evidence you will point to on showing that you have made an impact, right? Even things like if you founded a company and if that company had a very successful seed round or a pre-seed round or, had, evidence of being admitted into prestigious incubators or accelerators like Y Combinator or Techstars or things like that. Like those kinds of evidence can show that you are building a track record in your field. And enough progress in your proposed endeavor, showing traction, showing that your work is having traction, among individuals and associations that are relevant in the field, that could be very helpful towards meeting the second prong. Finally, the third prong is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And an easy way to think about this is that it is a balancing test. So on one hand, you think about the government's policy priorities to protect the U.S. labor market, but on the other hand, you have these broad systemic benefits that an NIW applicant can make, especially if they are helping the field advance, in competitiveness, for example, by introducing new technology, or if, the public welfare and health benefits of a particular endeavor is so broad, saving many lives in America, things like that. Those broad benefits may outweigh the ordinary benefits of protecting the U.S. labor market for one particular U.S. worker in the eyes of the government. So you can reuse a lot of the evidence that you previously we may have used for the first and second prongs, such as national importance related evidence, the positive impact your work can have, which is greater than the ordinary benefits that the government might get through the labor certification system. You can also point to some evidence that you used in the second prong if you can show that your particular unique skills and knowledge can't really be easily replicated by just somebody else in the United States with minimum credentials. That may also help tip the scales towards finding that on balance, it would benefit more to bring you in so that you can, provide your unique skills and knowledge that cannot be replaceable. So definitely, a variety of strategies is there to persuasively argue the third prong. And there can be a lot of overlap with the extraordinary ability criteria, where if you can show that you're someone who has, shown quite high distinction compared to the majority of other professionals in your field, you may be able to use that to your advantage in those criteria. All right, so let's shift gears a little bit and talk about the role of expert opinion letters, which tend to play an important role in all of the visa categories that we spoke about, including the O1, the EB1A, and the NIW. So what is included in expert opinion letters? Now, before we get into the content, it is also important to talk about who those letters will be obtained from. And really, the letters that we use can be quite varied depending on the purposes that we want the letters to serve. These can be letters from past employers. These can be letters from colleagues in your field, peer experts. It can also be letters from clients if you are trying to, provide evidence of the impact of your past work, for example. And if you, for example, for an EB2NAW, if you want to describe the impact that your work has had in a particular industry, you could get a client letter from that industry to speak to that. Professors, academics in a field can also definitely provide helpful insight on the caliber of your work, especially if you're a scientist and perhaps applying for an ONA or EB2NIW based on science. And Nobel Prize winners, obviously, not everyone has access to Nobel Prize winners, but the idea that you get is that you want to get letters from credible experts in the field who have decades of experience and who can convince the USCIS of, the validity of their opinions, right? Because of the extensive reputation and leadership they have accumulated in the field. So typically we would include a full-length CV, curriculum vitae with the letter. And it is important to provide that information because that will influence the weight that USCIS will give to that particular letter. So let's talk a little bit about independent letters versus inner circle letters. So when I speak of independent letters, I speak of experts who have not directly worked with you, but nevertheless know you through your work or through your reputation in the industry. And those letters can confirm that your abilities are outstanding in your field and could be helpful to have because sometimes USCIS will think that those types of independent letters tend to be more objective, right? So it is my recommendation to have at least a few independent letters among your collection of letters because if you only have experts that have directly worked with you in the past, those letters may not be seen as truly objective by USCIS. However, it is important to note that inner circle letters do play an important role in some contexts. So let's think about some ONA criteria. Critical role, for example. If you're trying to prove that you've played a critical role in a distinguished organization, it makes perfect sense to get an expert letter from the person that you've directly worked with in that particular organization who can provide a personal testimony of what role you played, why was your role important, what was the impact of your involvement in that particular organization. And those type of detailed letters can only come from someone who has personal knowledge of, the exact duties and responsibilities that you successfully completed. So in that case, inner circle letters can be a very important tool. So definitely speak to your lawyer to get, the right strategy on what mix of independent and inner circle letters to use. The content of these expert opinion letters can include things like discussion of your work, right? And that would be the most important thing. The letters can also mention any recognitions that you have received because of the work that you have done, your accomplishments and achievements. And really, it is important to be as concrete and detailed as possible in the descriptions that you include in those letters. If you, use ChatGPT to have them write a generic letter, for example, maybe they don't know of, the concrete details that only the people who were personally involved in your work can know. Really, it is a work of persuasion. The government is wanting to understand how does your work set you apart from others. And only repeating, hyperbolic and, adjective statements like this person's work was extraordinary without having any supporting concrete detail may not be very effective in persuading the USCIS officer. And there's actually guidelines that tell USCIS officers that they do not need to rely on conclusory statements. So any statements that merely repeat the regulatory criteria would not really be evidentiary probative. So definitely good to really dig out what are the details, the distinguishing factors that you can showcase that really shows, not tells, that your work is distinguished and set apart from the vast majority of other people in your field. So yeah, definitely be as specific as possible when you are working on those letters. All right, so now let's shift gears and talk about the strategic considerations that may come in when you're trying to decide which category to apply for between EB1, O1, and NIW, which are the categories that we spoke about today. So the first question is, do you want to stay in the United States temporarily or permanently? And as Kelly mentioned in the previous slides, the ONA and OMB are non-immigrant visas, which are well suited for temporary stays in the United States. And if you, for example, will maintain a strong connection to your home country and will spend a lot of time in your home country, this type of visa could be good for you. You can travel freely inside and out, and stay in your home country as often and as long as you want. Now, the EB1A and EB2 NIW are green cards, and really they are most well suited for people who want to live and work in the United States permanently. And once you do have the green card, you also open the possibility of US citizenship in the future as well. After you reside a set number of years in the United States, you could be eligible for that. So if your long-term goals are towards that, then the EB1A and NIW are a great step towards that. Now, keep in mind that being a green card holder not only gives privileges, but also has responsibilities. For example, there is a limitation on how long you can stay outside the United States to, maintain your green card status, maintain your status as a permanent resident. So this would not work for everyone. So definitely depends on your priorities and your situation. The other question to consider is, do you have a U.S. employer or agent, or do you want to self-petition? So the ONA and OMB is a category that requires either a U.S. employer or a U.S. agent to drive forward the petition. Technically, you're not allowed to self-petition for an ONA or ONB visa. Now, one thing to note is that if you are an entrepreneur and if you're the founder of a separate company in the United States, for example, now, and let's say you set up an LLC, you set up your own firm. Now, that firm, even if you have ownership in that firm, is considered a separate legal entity than you. So if you file the O1 through that company that you set up, that will not be considered a self-petition. It is very important, though, to remember that there needs to be enough evidence that there is actual work in the United States in your area of extraordinary ability. So it will probably not be enough to just have a paper company. You will probably want to get letters of intent or client contracts with third-party entities to really show that there is work lined up for that LLC when you file the petition. It's definitely there are strategic considerations that go into such kinds of fact patterns. So reach out to us and we'll be happy to have a consultation and speak in more detail about how that can work. On the other hand, the EB1A and EB2NIW are both green card categories that allow the applicant to self-petition, as we have discussed in the previous slides. So if you do not have that US connection, if you do not have the US agent who can drive forward the petition for you, you may consider those options. Finally, let's talk about family consideration. As Kelly mentioned earlier in the previous slides, for the O1 context, your spouse and children under 21 can join you and accompany you as O3 dependents. However, there is no work authorization available for spouses on O3. So the spouse and children are allowed to attend school, so that is one advantage. By contrast, the EB1A and NIW, those are both green card options, and if you qualify for those green cards, your spouse and children under 21 can also apply for green cards as derivative beneficiaries and can also be eligible for the work and travel authorization benefits if they are filing for the green card application in the United States by filing an I-485. So definitely that can be an advantage for some situations. All right. So some other strategic considerations when you are moving from a non-immigrant visa to a green card. So the first question to consider is the difference in the standard that the government uses for qualifications for extraordinary ability, right? So, as Kelly mentioned earlier in the previous slides, when we spoke about the Khazarian analysis, there is a higher standard to qualify for as an individual of extraordinary ability in the EB1A context, as opposed to the O1A or O1B context. So it is definitely worth noting that qualifying for an O1A or O1B does not mean that you automatically qualify for an EB1A. And so you do need to look at the strength of your evidence to see that they would also hold up in the EB1A context. And our team of experienced attorneys would be more than happy to help you analyze that. So that can be a good strategy for someone to, let's say, initially enter on an O1A or an O1B in the United States and spend the next 3 years, spend the next, several years on really collecting stronger types of evidence, additional strong evidence that can bolster each of the criteria if some of them were relatively weak before attempting to apply for the EB1A. It can be a long-term strategy for sure. But definitely strategic planning would benefit if that is your plan. The other thing to consider is timing. So if you are in the United States on a non-immigrant visa status, definitely consider how much time is left on your current underlying visa before moving forward to file an I-140 in either the EB1A or NIW category, because some visas can be harder to extend or can be subject to more scrutiny once an I-140 petition or green card petition is filed. And different visa types have different sensitivity to the non-immigrant intent question. And certain types of visas are called dual intent visas, where having filed an I-140 or green card petition would not affect visa eligibility. And the dual intent ones are the H-1B and the L visa category. And the O1 is also considered a little bit more lenient in terms of allowing there to be an I-140 filed, but you can still be eligible for the visa. But you do need to also always be ready to convince the officer that you're not intending to adjust status while you're in the United States. So that can be a challenge in consular processing cases as well. So there are a lot of nuances if you have an underlying visa and you're trying to move to filing an I-140. Definitely speak to us so that we can, assess your particular circumstances and advise you of the risks. Family considerations regarding timing. So if you have children who may also need the green card, it can be a good idea to consider filing for a green card early to avoid issues with the child aging out at 21 at which point they will no longer be eligible for the green card. So the last question we will look at before we go to Q&A is, are extraordinary ability categories available for entrepreneurs? And the answer is definitely yes. So the first point, the EB1A and NAW, as I mentioned before, both allow for self-petitions, which means that both are possible options for entrepreneurs. You do not need a US job offer. You do not need a different US company to sponsor you. You are able to self-petition for yourself. The other thing to note is that there has been changes in the EB2 NIW standard under the matter of Danazar, which is a case that came down in 2016, which did make NIW a much friendlier category for entrepreneurial type proposed endeavors. And actually, the matter of Danazar does, in fact, talk about entrepreneurs and how it may be impractical for an entrepreneur to qualify for a green card using the traditional labor certification process, because they have ownership typically in their own companies. So definitely entrepreneurial endeavors are contemplated as possible endeavors that can meet the national importance criteria under the eyes of the government. Finally, one more note that I've alluded to this earlier, but it is possible to apply for an O1A as an entrepreneur if you have extraordinary ability in your field, if you have a separate corporate entity in the United States that can serve as the petitioner that can file the O1 petition for you. Okay, so that is all that we have prepared for you today. Let us go to the Q&A. So there's one question that came in regarding work experience. Does the work experience need to be from the United States? And can I use letters of recommendations from outside the United States? So there is no restriction that the work experience is from within the United States. And I'm assuming that this person is the question is relating to meeting the 5-year work experience requirement for the EB2 threshold, for example. You can definitely use work experience from outside the United States as long as it follows the acquisition of your bachelor's degree. All right. So it looks like there has not been any other questions that came in. Thank you everyone for your participation, and hope this presentation was helpful to you. And we look forward to seeing you in the next one. Thank you, Kelly.
Thank you.